Chairman,
my name is Richard Daly. I'm with the law firm of Daly and Black, and I represent insureds in these matters. I don't think you'll hear from a lot of attorneys who do represent.
What's your position on the bill, real quick?
Opposed.
Okay.
And I would invite questions on any issue, although I'm here to talk about one. I represented Mr. Kirkwood Church in that matter. And the major problem I have, and by the way, I appreciate the willingness to meet and with both sides and alter the bill. It's still got a couple of major problems, in my opinion. And the one that I think is the biggest problem now is the notice provision. The problem is not that you have to give notice. The problem is not that you have to give an amount. The problem is that you have to give notice before you get into the file and with a crystal ball guess what your damages are and figure out what a jury's going to do 2 years down the road. And if you're not right, if you guess too high, then your attorney's fees are going to be cut accordingly. So maybe this is a bad analogy, but it's almost like if you were to do brain surgery and you had to anticipate how that was going to turn out. And if it didn't turn out as well as you said it was going to, then you're not going to get paid everything.
Yeah, can you get a little bit closer just so we make sure you get it?
Sure. You're right, it's a bad analogy.
Okay. Well, you don't have to deal with that, fortunately. And then that's what the problem is. So
let me ask you that, because you know, in thinking about how this would work in an actual case.
Okay.
So this is well after you've you've been retained in whatever fashion, you've done your investigation, you made sure notice letters were sent to them under the different codes, whether you do a DTPA or you do insurance code violation.
Right.
So you've already done through that. So you're getting close saying, hey, I think I need to go and file a lawsuit. I'm going to do it at least 60 days before statute runs.
Sure.
Are you saying you don't have an idea at that point of what your damages are? That you're going to guess too high?
It's not that. Yes, absolutely. You are going to guess too high, and here's why. For a couple of reasons. One, out of an abundance of caution, because it's Law 101 or Negotiating 101 that when you're trying to negotiate anything, whether it's a business deal or with an insurance company, you don't start where you want to end up. Okay. And when you're handling these types of cases, what you have to do is envision, when you give this notice now, okay, you have to envision, what's the gamut of possibilities. Where can I possibly get to? Because if I start too low, then we're only going to go lower when we negotiate. And that's what this bill is designed to do, but for the insurance companies, okay? And I don't think intentionally, but that's the practical effect it has, is that you've got to negotiate low or start low and negotiate lower. And let's take the church, for example. In that situation, you had about 15 different leaks over the course of 15 different rooms. And you can ask 5 different engineers what it's going to cost to fix it. You're going to get 5 different answers. Well, which one do you go with? But, the one...
I guess you would say you'd go at the highest, because you should always go higher, because you're going to start at your highest. But, Negotiate 101, that's what we're doing here.
Sure, you'd go with the highest. Yeah. And then, you have to predict what a jury does. A jury comes back, and that particular situation, for example, what we settled it for, if that's what the jury gave us, we would have gotten 50% of the attorney's fees. Now, you're not hurting the attorneys. Okay, what you're doing is you're hurting the insured, because they've got a contingent fee agreement. They got to pay 40% of whatever the award is. So they're going to have to come out of pocket to actually fix their actual damages. So what's the fix? The fix is real simple. You said, Mr. Chairman, don't you think it's fair to notify them what the damages are? At some point in time, you've got to tell the jury what you're asking for. Well, that's what if you're going to give them a notice provision and then weigh that for calculating attorney's fees, well, then go off of what you asked the jury for, not what you were predicting is going to happen 2 years prior to suit, because you haven't gotten into it. You haven't hired engineers. You haven't. There are many cities, for example, that have codes that require upgrades. You're not aware of all that stuff.
Yeah, but that would only increase it. It's not going to decrease it.
No, but that's not entirely true, because a lot of times you have, let's say you have $500,000 of damages, you're rock solid on it. But if you don't have code upgrade coverage, which you oftentimes don't know, or you don't know what the city's code is, then you're going to end up getting a lower amount and going to be entitled to a lower amount. I mean, that's the problem you run into. It's not the notice. Nobody has a problem with that. It's the timing of the notice, or at least the opportunity to amend.
So you give a notice in every case before you file suit?
We file suit and give the notice roughly at the same time. Because right now,
why do you do that?
Because I've one time, out of hundreds of lawsuits, one time I've had an attorney call me to try to resolve it in that 60-day period, and that was Chairman of the Calendars Committee, Todd Hunter. He's the only one that does that. Nobody else even makes an attempt. So because the courts have said, well, you can just abate it for 60 days, we file suit at the same time, because that way you can get a trial date earlier and get the clock rolling. So, if they would try to negotiate these, no problem. They don't. As a practical matter, they just don't.
Questions, members? Oh, we got one over here.
Sure.
Yeah, I have a couple of questions. So I appreciate your testimony, and it's great to be able to talk to somebody who actually, works through these cases and kind of understands how they work. So I'm trying to understand with regards to the estimate. So the chairman was asking, towards the end, this is not a brand new situation. By the time you're within that window of statute of limitations, you probably have had multiple estimates. You mentioned, you might have several appraisers come out and say, is it really unreasonable to think that 20%, to be within 120% of each other is, shouldn't they be kind of in the same ballpark?
Well, no. I think it is unreasonable, and here's why. The goal here in these cases, for example, the church, is to get the problem fixed as fast as possible. Every single time it rained there, they literally had baby pools sitting around collecting water. Okay? So what we're trying to do is get that thing resolved. We can't wait 2 years till the statute of limitations runs and we go and interview every engineer in Amarillo and talk to every public adjuster and general contractors and get bids and find out and have people, do investigation into the roof. It's just not feasible. That's what's done while the lawsuit's going on, while the discovery process is going back and forth. That's the most efficient way to handle these matters.
Okay, and then I guess my second question just kind of relates to the recovery of attorney's fees. So I'm trying to understand. So in the situation that you described, so the gentleman is able to recover 50% of his attorney's fees, but you were representing him, and I guess he had an agreement with you that it was going to be 40% or something like that. I guess my question is, is that, I understand that's the way things work to a certain extent in the legal world, and you win some, you lose some kind of thing, but isn't that, I guess what I'm asking is, at some point, that 50% sort of becomes the new standard, or 80% or whatever. Isn't the system just going to adjust to compensate for that, or... You know what I'm saying?
Well, as Dr. Bonnet said, and I wrote it down here, what we're trying to do here is help homeowners. And if he says it's always best to do what needs to be done and no more. Well, that doesn't need to be done. These laws were passed initially so that we could get homeowners and businesses made whole. And that's why you get attorney's fees and interest. The interest and the attorney's fees are going to cover the expenses, and then the homeowner or the business gets made whole, and they actually, and they've got to pay their deductible. Fine, but why should they have to eat part of the attorney's fees because the insurance company was a bad actor? That's not right. That's not what we're trying to fix here. I don't think.
It's not only that they were a bad actor. It's that what you're saying is that you guessed wrong. It's only if you guessed wrong.
Well, right, but why do we want to?
No, I'm just asking. Guessing? But you just said it's because they're bad actors. You got. We're gonna.
Well, you're not going to win unless they're a bad actor. They breached the contract, or you're getting nothing at a minimum. And then if they actually committed one of the statutory violations, you can get additional damages.
And a jury gets to decide that, right?
That's right.
Let me ask you: do you do these homeowners claims as well?
Yes.
Okay.
In fact, I represented Ms. Knippa as well.
Oh, okay. Okay. What's did it just happen to? I guess it was good that you ran into him here then. Yeah, interesting. That's kind of cool. You got any other clients over there? And I see why they want to hire you too. Yeah. Thank you for your testimony.
Yeah, sure.
We got one over here.
I'm trying to follow through the how this case would be a problem with what we're doing. So if you're a normal homeowner, and the woman that was from Travis County, I asked her also, and she agreed with what I was saying here, that if you have a normal homeowner and I have a problem with my insurance agent or my insurance company meeting my deal. I know what my costs are to repair my structure. I got estimates from contractors or whatever it is it takes to do my repairs. Otherwise, I wouldn't be disagreeing with what the insurance companies told me. I had to have some number. I would just accept what they said. So why would you have a problem with a homeowner, which I know 90% of them are going to know what their costs are to have a repair. Then they file the suit. Within 60 days, they would have to tell you what that number is. They know what that number is. So why is that going to be a problem?
Because they don't know what the number is.
Why?
Because you have, so for example, most insurance companies will hire either Donen Engineering or Hague Engineering. I've handled hundreds of these lawsuits. Not once has either one of those engineering firms ever said there was damage. Not one time. So how can an engineering firm who's licensed by the state come out and say there's no damage when I've got an engineer that says there is damage? And a jury's got to decide one or the other. And they don't pick one or the other typically. They pick somewhere in the range of the middle.
You're getting the semantics. I mean, if there is damage, the guy, I'm sure what the report might say, the wind didn't cause the damage, not there is no damage.
No,
anyway, I get it. But that doesn't change anything that the homeowner will have the cost of his repairs. I don't. What you're saying, what your testimony is saying is that the homeowner wouldn't know what it's going to cost to repair their house.
It's not that they don't know what it's going to cost. They don't know what the damages are. It's so, I mean, take an even.
But so now you think that they don't even know where their house is damaged?
No. It's not whether or not it's damaged. It's how.
That's what you just said.
Take a refinery, for example. How are you going to come to the penny with within the damages that a refinery down in Freeport, for example, suffers? I mean, it's impossible to figure out what the damages are at the beginning. Again, the point is not that you can't ever figure out the damages, but you can't do it at the beginning of the case. No. That's why every single court gives you a certain amount of time to designate an expert and actually state what your damages are. That's when this election ought to be made, not the beginning.
It's unlikely a refinery is entered into a 40% contingency agreement with the council.
Well, okay, then they're paying on an hourly basis. They're still going to get it cut if they overestimate. I mean, that's the point. I mean, it doesn't do any good.
The problem looks like weird. This problem you're talking about would only come in is if I go hire a lawyer in the beginning of this process. Say a storm happens and some guy comes and knocks on my door and says, "Hey, I want to help and be your attorney and go through this case," and I hire an attorney and he sends in a notification. That would be the only time that this scenario that you've dreamed up would take place.
Under that scenario, then it needs to be reported for barratry because you can't do that, first of all. And this firm doesn't do that. But
maybe only engineers can do that.
Engineers don't do that. Right. But I'm just saying that because typical case, like I said, the guy's going to know his damage. It's like Chairman said earlier. You know, you're going to know what your roof costs. I know what those are. And then I go in and if the insurance company disagrees with me, then I'll go sue over that. I know those costs. The only example I could think of that fixes this guy knocking on your door.
And you may know the cost, but I guarantee you that the Doris Knippas of the world don't know the cost. And that's 99% of the people out there.
That was the Travis County. I just asked her. She said she knew her cost.
No. That was she walked out. She was the one in Brazoria County, in Alvin.
Oh, okay. No.
Mr. Chairman, I just have a question.
We're going to have two more questions and we're going to move on. Sure. I've been told we got to hurry. So
okay.
Two more and that's it.
And I'm happy to meet with any of you guys outside.
I don't mean
of
questions. I mean questioners.
Oh.
Ask as many as you want.
Thank you.
Yeah, no, I just wanted to clarify. I think the lady who was had the papers and was saying what she went through had told us that she had already spent $10,000 out of her own pocket to get somewhere with her company.
Sure.
And I guess the issue you mentioned about the notice is that before you file the lawsuit, you would need to make a good faith estimate as to what your damages are. So the question becomes, I mean, what is a homeowner supposed to do, right? I mean, are they supposed to get on the roof? Are they supposed to analyze the damage, for example, through the sheetrock to see how much damage there is through the insulation? I mean, we don't know that.
That's exactly right.
And I think that's probably maybe what's lost a lot in this discussion is that, I mean, what is for example, the statement of acts or omissions giving rise to the claim? Well, I mean, you don't necessarily, what would the homeowner know as to what the agent or the company hasn't done or not? I mean,
right? They don't typically.
I mean, you know what the catastrophic event was? Yeah, it was a hailstorm. Okay, well then, I mean, what are you supposed to do next?
Right.
So I mean, I just want to clarify that, because I think the lady was clear saying, look, I don't have a problem. The issue is that I've already paid $10,000 out of my own pocket, and here I am, I don't know how many years later, trying to figure out when am I going to fix my house.
And still not sure what the full amount of damages are. Right.
Thank you.
Over here.
Yeah, thank you, Mr. Chairman. Mr. Daly, help us understand, say, under this bill, or forget the bill, but under current law, so after you've filed a suit, served notice and filed a suit, and then when you would go to trial, if it actually goes to trial.
Right.
Help us understand the steps you as legal counsel would take to present the best information possible to that jury to make your case in terms of inspections, discovery, things like that. Because I think that's part of what there's some questions on. So people are asking, why can't you make a good faith estimate and be 80% you're right or in the ballpark? And I think you're saying there's a lot of steps that occur between when the suit is filed and when it would actually go to a trial that help inform what the final jury decision is if it gets to that point.
Right.
So can you help us understand what those steps are?
Sure.
That take place
and I'll tell you how our firm does it. And the first thing we do is we hire somebody to go out there and look at the damages and do an estimate. And they are instructed to put in everything that we could potentially recover, assuming an all-risk full policy. Now, we don't have a copy of the policy oftentimes. Believe it or not, most homeowners don't have a copy of their own policies, okay? So once we get the policies, then we're able to look at it and figure out what exclusions there are and what the damages actually might be. In the meantime, we're making an effort to contact opposing counsel to see if we can't get it resolved without any further litigation. And then you have, almost up front, the insurance company's attorneys have the right under Rule 167 of the Civil Practice, or not Civil Practice and Remedies Code, under the Rules of Civil Procedure, to make a settlement offer. And if you don't beat that settlement offer by 80%, then they get their attorney's fees. So, I mean, you already have this in place, but this law is trying to add an extra piece that would not only get them their attorney's fees, but not get you your attorney's fees, okay? But after that, then we'll have an expert report. They'll have an expert report. We'll get a chance to depose their expert, and oftentimes their experts do come up with some issues that we hadn't thought of. Like, for example, this particular roof doesn't require you to comply with city codes because it was a composition shingle roof, not a wood roof. And if you look at the policy, the way it's worded, it doesn't call for that. So there are things that, over the course of discovery, you figure out what your damages actually are. You also get to figure out how bad of an actor they really were, so you can see whether or not there's a possibility to treble damages, where you could never put that in the initial notice because you have no idea if you're
there's nothing in here that requires you to do that either.
Well, but if you did it and you don't get it, now you lose your attorney's fees.
No, that's not what and maybe if fair enough, you haven't seen it. It's the property damage.
Oh, you're right.
Yeah, no, it's okay. I just want to make sure we're all the same because
You're right. That's not applicable.
That's probably
I hadn't thought about that.
One of your arguments probably why it
well,
probably didn't look like
don't
that.
even ask for those types of damages. But the point being that during the discovery process, you get their entire file, you get their entire expert's file, you give them their file, and then everybody. This is why we're able to settle these cases 4, 5, 6 months into it, because then you have the full amount of information that you need to resolve these cases, and that's why we resolve 99% of them before trial.
So bottom line, there's a lot more information available to all the parties involved after the suit's been filed than before the suit's been filed.
That's exactly right.
Okay. And in the examples you were giving on pertaining to a single family home, that you'll discover things throughout the process. I assume, let's say it's a 40-story skyscraper in downtown Fort Worth that gets, basically obliterated by a tornado. And it's a real example because that happened about 17 years ago in Fort Worth. I imagine that's much more complex in terms of the inspections and the expert reports and ascertaining exactly what the damages are. Now, I don't know if those went to litigation or not, but that's since this bill pertains to all violent acts of nature, I think is the term, something like that is a real example, is it not? That
sure,
it would be very difficult to accurately project what the damages would be.
And it doesn't even have to be to that extent. You had a tornado up in Rowlett that leveled the neighborhood. Well, now, I mean, you know, it's easy to say a home cost $250,000, but, you know, did it cost $250,000 back then? What, you know, and you have to go through the whole list of items that they had. Did they have marble tile? Did they have Formica countertops? I mean, who knows? I mean, it's just not that easy at the very beginning to figure out what your damages are. By the end of it, sure.
Okay. Thank you.
Thanks for your testimony and coming today.